Straight ahead on Law and Crime Daily. Britney Spears to speak to a judge about her conservatorship case. What will the pop icon say about her 13-year-long legal battle?
Hey! Britney! Hey! Britney!
And a juror speaks out in the Derek Chauvin trial as we learn what went on in the deliberation room. Plus, why a North Carolina judge is blocking the release of body cam footage in the fatal shooting of a man by deputies. And the Tennessee man appealing his life sentence for the torture and murder of a couple in their 20s. The testimony of Eric Bowen's co-defendant, attorneys say, was key for a conviction.
Thomas's testimony was that the defendant led Mr. Newsom to the vehicle, drove him to the train tracks, shot him 3 times, and set his body on fire.
Law and Crime Daily covering court day in court. Terri has more.
A judge is allowing Spears to speak at her next hearing about her conservatorship.
Hey, go home! The conservatorship has got to go!
Fans of Britney Spears are fueling the Free Britney movement. They support her bid to end her 13-year-long conservatorship.
She gets allotted a certain amount of money per year, and she's a worldwide pop star. She should have control of her own funds, her own money. And to me, Britney Spears is such a sweet soul and such an intelligent artist.
After years of silence, the pop star now says she wants to speak to a judge herself. Probate attorney Samuel Ingram was appointed to represent Spears. He told a Los Angeles County judge on Tuesday that Spears would like to address the court on the status of her conservatorship.
Anytime there's that amount of money to be made, you have to question the motives of everyone close to that person.
Her case received new attention after the New York Times documentary Framing Britney Spears. Spears recently posted on Instagram that she didn't watch it, but, quote, cried for 2 weeks and, well, I still cry sometimes.
Am I okay? Yes, I'm totally fine. I'm extremely happy. I have a beautiful home, beautiful children. I'm taking a break right now because I'm enjoying myself.
Her father, Jamie Spears, has been conservator of Britney's estate since 2008. Britney's attorney has said she fears her father and wants him removed.
The conservatorship has got to go!
Last fall, the judge appointed a trust as co-conservator, but that has yet to take effect. A separate hearing on the matter is scheduled for July. Spears is set to appear in court on June 23rd.
Thanks, Terri. Joining us today is former prosecutor and defense attorney Bernardo Villalona. Terri, what do you think we should expect if Britney Spears does come to court and speak at her hearing?
Brian, you know, it's clear that she is not satisfied with the way her estate is being run, and I think we're going to hear her talk about the fact she's been handling both her personal affairs and her business affairs. We know for a fact that her children are well taken care of, and we know that she has been producing music. So there's no question, I think she's going to try to show the court that she can take care of herself. There hasn't been any mental distress, and it's time that she be able to take control of her own affairs.
Bernardo, how powerful could it be to hear from Spears herself? Do you think that this could be more persuasive than what her lawyers have said on her behalf?
Well, depending on how she comes off to the court, it's going to be a huge decision-making factor. But I think the court, it's time for Britney Spears to actually speak up for herself, because you have all these people serving as the voices for her, saying that she's not competent enough to handle her own affairs. Here, the judge is going to be able to access that himself by hearing her speak out.
Yeah, exactly. I think what she says, how she says, her body language, all of that is going to be on display, and that's what the judge is probably going to make their decision on. It's going to be interesting. It's also going to be interesting to see how this plays out for the Free Britney movement when her fans see her as well. Now to the Derek Chauvin trial. The first juror who deliberated is speaking out, telling ABC News they reached their guilty verdicts in about 4 hours.
Yeah, so for me, I'll say 2. For sure, Donald Williams, just how he spoke about everything, and Dr. Tobin. I think once Dr. Tobin got on the stand and the way he spoke and the details that he gave and the way he gave the details, I thought that really solidified the prosecution's case.
Derek Chauvin not taking the stand, did that have an impact, not hearing from him, the former officer?
Yeah, definitely it did. When we were in the deliberation room, a few people wondered, they wanted to actually hear from him. They were curious on, just what his thoughts might have been throughout. you know, it probably was to his detriment that he didn't take the stand, because people were curious on what his thoughts were throughout the entire incident.
Bernardo and Terri, you both covered the Chauvin trial. I'm curious about your reactions to what juror Brandon Mitchell said, and if you think, especially on that issue of whether or not Derek Chauvin testified, if you see any appellate issues. Terri, your thoughts?
Well, overall, as far as the interview, I liked what he had to say. He talked about the family. He gave his condolences. He said it's important to make sure that you show up to have a voice. And I thought that was important. As far as the appeal is concerned, it did bother me a little bit that he talked about the fact that not getting on the stand might have worked to Chauvin's detriment. We know that there's a jury charge that says you cannot use that against him. The question is whether or not that will be jury misconduct. I don't think it will be, but it did concern me that he verbalized that.
Bernardo, what do you think?
So I am concerned about that last part of his statement. So for them to comment on the lack of Derek Chauvin having to testify and that possibly played a role in their deliberations can be an appellate issue for the defense, because as you know, the defendant is not required to testify at trial, and they're not supposed to hold it against him if he does not testify.
Yeah, it's going to be curious. From what I understood, the gentleman said that they were curious as to what he would have said, thought it might have been to his detriment not to testify. It sounds like he got close to, and Terri, I'm curious, follow up, sounds like he got close to holding not testifying against him, but not quite there. Terri, what do you think about that?
I agree with you, Brian. I don't think it's quite there. I mean, I think the other issues, like the legal error, the failure of the judge to change venue or sequester the jury, I think those appellate issues might be stronger than the jury, quote unquote, misconduct. I don't think he got to the point of saying that issue would have been misconduct.
Really quickly, Bernardo, would you expect a lot of appeals in this case?
Absolutely, from the very beginning all the way to the end, because Eric Nelson did do a great job in terms of preserving the record, preserving his objections for appeal.
All right, we'll see how that plays out. Still ahead on Law and Crime Daily, a cold case from 19th accident in Queens when he was struck by a Volkswagen. The NYPD later identified 32-year-old Jessica Bouvet as the driver who killed the 14-year-old veteran of the force. During his final moments, the officer rescued 2 people from the earlier crash. Sakos leaves behind his wife, a 6-year-old daughter, and 3-year-old son. And out of New Jersey, the so-called torso killer has pled guilty to another set of murders. Richard Cottenham admitted to the 1974 deaths of a 17-year-old Mary Ann Pryor and 16-year-old Lori Ann Kelly. Cottenham was already serving a life sentence on 5 other murders from the 1960s. 74-year-old Cottenham is known as a torso killer for the way he dismembered his victims after their deaths. Singer-songwriter Trey Songz will not face charges after an altercation with the police. The R&B artist was arrested at the AFC Championship game for not following coronavirus protocols as well as other rules at the stadium. Trey Songz, whose legal name is Tremaine Alden Neverson, spent the night in jail. Prosecutors say there's insufficient evidence to bring charges. Trey Songz' representatives declined to comment on the event. Now to North Carolina, where a judge is delaying the release of Sheriff's Office video showing the fatal shooting of Andrew Brown Jr. Brown was killed last week by deputies serving him with an arrest warrant. An independent autopsy commissioned by his family reportedly shows he was shot 5 times with a fatal wound to the base of his neck. His family and attorney was able to view a redacted portion of body cam footage on Monday, but North Carolina law prohibits law enforcement from releasing the video without a judge's order. On Wednesday, news organizations argued the 5 body cam videos and 1 dash cam video should be made public. County Judge Jeffrey Foster said at the hearing, quote, "The release at this time would create a serious threat to the fair, impartial, and orderly administration of justice." He ordered the video not be released for at least 30 days. The family would get a redacted copy in 10 days. In this newly released surveillance video by Elizabeth City deputies are seen arriving outside Brown's home. They piled into the back of a pickup truck and turned into his driveway. Back with us is criminal defense attorney Bernardo Villalona and Terri Austin. Bernardo, a delay in the release of 6 videos for 30 days. Is the judge merely punting the issue, or does this delay make sense?
So it does make sense, Brian. You got to think when it comes to doing investigations, what the judge doesn't want to see happen happen, or any prosecutor's office wants to see happen, that the release of the video footage taints and makes the investigation more biased. So by not releasing the video, then they can do an investigation without having the officers having spoken to each other, tried to come up with a plan as to what they're going to say actually happened. So it does make sense in that sense that it's not released to the public. However, it will be released to the family, actually to the son, within 10 to 15 days.
Now, Terri, to that point, the family would be able to view the video. Should we expect them to release the whole video then?
My understanding, Brian, is that they're going to be able to view the video. It will be disclosed to them. I don't think it will be turned over to them. So they would not be in a position where they would be able to release it. The judge has said that it can be viewed in 10 days, that the police face will be blurred, the officers' faces will be blurred, and he apparently will review the video to determine whether or not certain portions should be cut out, like the conversations between the police officers and their supervisors. If you recall, that was done in the Derek Chauvin trial. Then in 30 to 45 days, we will perhaps see the release of the video to the public.
So it's not a question of if, rather of when. I guess that's what we'll have to wait and see, 30 to 45 days, unless there's going to be further arguments that it should be pushed back. Thank you both. Coming up on Law and Crime Daily, convicted for the torture, rape, and murder of a Tennessee couple. One defendant is now seeking an appeal. But first, the shocking reunion during a first appearance in Florida, the judge, the inmate, and their reaction after the break. As a public defender, I know firsthand you never know who you might see in a bond court. And Law and Crime founder and host of the A&E series Court Cam, Dan Abrams, explains sometimes even the judge can be caught off guard.
Stand up and raise your right hand to be sworn, please. Please stand up.
Next, we head over to the Miami-Dade Bond Court in Miami, Florida.
The one sleeping there, you can wake up too in the back row. Number
where Judge
4,
Mindy Glazer is overseeing bond hearings.
Thank you. I have a few announcements. I'm going to appoint the public defender to represent all defendants unless you tell me you have money to pay for a private lawyer, or if you are hiring a private lawyer and one is here. Also, please let me know if you have served in the United States military or any of the reserves. Good morning.
Good morning.
Over the next few hours, she'll see dozens of defendants.
You were arrested for second-degree murder.
As they step in.
I'm in the military, Your Honor.
You are?
And quickly step out.
Hi, Mr. Booth. How are you?
How you doing, ma'am? Okay, ma'am.
49-year-old Arthur Booth is a career criminal, charged with burglary, grand theft, fleeing, and resisting arrest.
You have actually 3 arrest affidavits: reckless driving, damage to property, leaving the scene of a crash with serious injury.
With no serious injury.
I'm sorry, no serious injury.
Okay.
After questioning, Judge Glazer explains the terms of his bond.
The bond on count 1 is $7,500.
But the judge notices something familiar about this defendant.
Okay, Mr. Booth, I have a question for you.
Yes, ma'am.
Did you go to Nautilus for middle school?
Oh, my goodness. Oh, my goodness.
I'm sorry to see you there. I always wondered what happened to you, sir.
Oh, my goodness.
This is the nicest kid in middle school.
Oh, my goodness.
He was the best kid in middle school. I used to play football with him, all the kids, and look what has happened. I'm so sorry.
Oh, my goodness.
The surprise reunion between the 2 former middle school classmates is almost too much for Booth to handle.
Oh, my goodness.
Once a promising student, Booth fell into drug and gambling addictions that led him into a life of petty crime, resulting in multiple stays in prison.
Oh, my goodness.
Good luck to you, sir. I hope you're able to come out of this okay and just lead a lawful life.
The reunion somberly concludes as Glazer sets bail at $43,000.
Okay. All right. Oh, my goodness. Oh, my goodness.
Booth is sent to prison for 10 months and then released into a drug treatment program.
Court Cam airs Wednesdays on the A&E network. When we come back, convicted killer Eric Boyd is seeking an... Welcome back. A Tennessee man convicted for the 2007 kidnappings, rapes, and murders of a young couple is seeking an appeal. Eric Boyd was sentenced to spend the rest of his life in prison, but his attorney says he was wrongfully accused.
The way how she was positioned and...
Ms. Christian was beaten and raped, then trapped inside a trash can. Her boyfriend, 23-year-old Christopher Newsom, was also raped before he was shot 3 times in his head, then lit on fire.
The fire now is superimposed on everything, on all the gunshot wounds, and also if one is alive during fire, then the inhaled soot and all the fumes from the fire are going to be deposited on the airway, and there was none of that.
The couple was heading out on a date on January 6, 2007, when they were carjacked in front of their apartment. 4 people were arrested and charged with their kidnappings, rapes, and murders. A 5th, Eric Boyd, was convicted of carjacking. But in 2018, Boyd was indicted on 36 charges, including murder, after co-defendant George Thomas agreed to testify against him. Prosecutors offered Thomas a reduced sentence from life in prison to 50 years.
When you saw the 3 flashes, who did you see pulling Mr. Newsom?
Mr. Boyd.
And where did he pull Mr. Newsom to?
Directly before me and to the back of the building.
What happened after he pulled Mr. Newsom to that location?
He came back and grabbed the can of gas.
Who did that?
Mr. Boyd. A jury found 47-year-old Eric Boyd guilty on all counts, and he was given 2 life sentences. Now, Boyd is appealing, saying Thomas's testimony is uncorroborated and that the jury pool was tainted due to media coverage.
It is our position that the evidence is insufficient because Mr. Thomas was a co-defendant, he was an accomplice, and the well-known rule is that you cannot convict a person based solely upon the uncorroborated testimony of a co-defendant or an accomplice.
But prosecutors say the medical evidence and testimony of other witnesses corroborates Thomas's story.
Ms. Mathis's testimony from federal court that she loaned the defendant her white Pontiac the weekend of the offenses corroborated Thomas's testimony, and Xavier Jenkins' testimony that he saw Mathis's Pontiac, which he identified in a photographic lineup, parked behind Ms. Christian's 4Runner at the residence on the night of the offense, also corroborated George Thomas's testimony.
Let's bring in Bernarda and Terri one last time to discuss. Bernarda, the prosecutor who actually graduated from law school with me, laid out why the testimony was corroborated by the co-defendant. Was that persuasive to you?
Yes, it was definitely persuasive. You know that when it comes to putting up a person that is a co-defendant, someone else who played a part in the crime itself, that the court and jurors look down upon this type of testimony. That's why it's so important that there's corroborating factors, corroborating evidence to actually corroborate what this person is saying. And there was more than enough corroborating factors, such as the entire testimony of the medical examiner, as well as the other ladies that also took part in this incident.
Now, Terri, I noticed that the judges had few questions for the prosecutor, and the defense, who said they wanted 5 minutes for rebuttal, actually gave it up at the end. Is that a sign that we should be seeing one side might be winning this appeal over the other?
No question about that, Brian. You never want to give up an opportunity to argue on behalf of your client. I think clearly in this case, the defense was thinking to himself that he had a losing argument. You heard him there talk about it was insufficient evidence because the co-defendant was the only corroborating evidence. And Bernarda mentioned, no, that wasn't the only evidence. And in fact, the judge asked him, even if it had been, that would have been okay. The case law supports that. And in fact, we didn't even hear a response from the defense attorney. At that point, he said to himself, well, okay, Judge, yeah, I guess maybe you're right. So he clearly was either not arguing well on behalf of his client, or he just, didn't do his research. But clearly giving up that rebuttal argument, he gave up and basically, I think, didn't do a great job arguing on behalf of his client.
Now, Bernarda, one issue came up that's interesting. It's very similar to New York, the exhaustion rule when it comes to picking a jury. That seemed to be an issue here because the defense had more preempts to kind of get out some of the jurors. Could that be an issue that hurts the defense here?
No, I don't think it's an issue that's going to hurt the defense, because in the end, the court is going to determine, based on looking at all the facts and all the evidence that was presented in the case, was it harmless error? Was that an error that could have changed the outcome of the case?
All right, thank you both. And thank you for joining us here. We'll see you next time as we discuss justice in America.